Right. Good morning, everyone. Good afternoon. I'm Maria Antonia Tigre. I'm the Global Climate Litigation Fellow here at the Sabin Center for Climate Change Law at Columbia Law School. I would like to give you a very warm welcome for this wonderful webinar on children's rights and climate litigation, which was wonderfully organized by Esteropi, who will moderate this and take us further. I'd just like to mention very briefly that this is part of the work of the peer review network on global climate litigation, which we hold at the Sabin Center, which is a network with over 100 people that help us maintain the database, our global climate litigation database, and also engaged in really brilliant discussions on what's happening with climate litigation worldwide. So Serapi, you can take it over from here.
Thank you very much, Maria Antonia. Good morning, good afternoon, and good evening, everybody. And thank you so much for joining our webinar on children's rights and climate litigation with a focus on future generations and the emerging trends in children's rights law. I am Esteropi Iliopoulos, and I am a PhD candidate at the Cardiff School of Law and Politics, investigating child participation in climate change litigation. Today, I have the privilege to facilitate the discussion between esteemed colleagues and leading experts in the field. And I couldn't be more grateful for the panelists who have joined us today and for the wide participation we have seen in this event. So the structure will be for the panelists to share their insights and presentations, and then we will open the floor to questions and answers. So please do feel free to post your question in the chat, and hopefully we will answer as many as possible. Before we begin, a huge thank you to Maria Antonia for all her work on the platform for national rapporteurs, which allows us to come together and put up events such as today's webinar, and also to the Sabin Center team, to Kemi and Tiffany for supporting us with all the logistics. So without any further delay, I am delighted to introduce our first panelist, Professor Aoife Nolan. Professor Aoife Nolan is a professor of international human rights law and co-director of the Human Rights Law Centre at the University of Nottingham. Her professional experience in human rights and constitutional law straddles the legal, policy, practitioner, and academic fields. She is president of the Council of Europe's European Committee of Social Rights and has acted as an expert advisor to a wide range of international and national entities working on human rights issues, including the Council of Europe, UN Special Procedures, and the World Bank. She is currently advising the UN Committee on the Rights of the Child and the UN Committee on Economic, Social, and Cultural Rights on their respective forthcoming general comments. And she's an academic expert member at Doughty Street Chambers, where she co-leads the Children's Rights Group. She now leads a groundbreaking 3-year research project on advancing child rights strategic litigation, bringing together partners from advocacy and academia from 3 continents. Her current academic work focuses on the relationship between the rights of children and future generations, including the implications of such for the judicial role in climate change litigation cases. Thank you so much for joining us, Aoife. The floor is yours.
Oh, well, thank you so much. And thank you, Esteropi, and to the Sabin Center and to Maria Antonia for hosting this event, which I think is important and timely. May I just check if you can see my slides? That's great. And I want to, I'm already on slide 4. That's a good start. I want to very quickly begin by expressing solidarity with the children and young people who are currently out on a global climate strike today on the 3rd of March, and to wish them well in their work in that area. It's obviously an enormously important, the entire discussion around children's rights and future generations' rights in the context of climate change has been shifted as a result of actions such as the global climate strikes and the FFF movement. And I just want to pay tribute to that, because I honestly don't think we'd be here if it wasn't for the activities of children and young people pushing the envelope and forcing litigators to push the envelope as well. So what I'm going to talk about today is I'm going to talk about climate justice litigation, the rights of children and future generations in the courts. Now, I realize in an act of absolute crowning genius, I proceeded to ensure a situation where I cannot actually see my notes. So I'm just going to very quickly email them to myself so that I can ensure that I don't talk for 982 minutes. I have to apologize before I begin. I have ongoing lingering COVID. So You may find that my slides are agonizingly detailed, but let me assure you that is just to make sure that we don't have a situation in which I completely lose the run of myself due to a brain fog outbreak. I want to talk about three things today in my comments. I want to start with a discussion of where we're at, what we're seeing happening in this area around the litigation of children's rights and future generations' rights. I want to then turn, and why is it happening? Why are we seeing all this litigation involving the litigation together of children's rights claims and future generations claims? What's the reasons for this? I think it's important to have that in the background because I think it gives us a broader sense of the context in which this litigation is being brought. I then want to talk about the challenge of definition very briefly, and the issues that are faced with regards to which issues around what are future generations, what are children, and how this feeds into and creates complexity for litigators working in this field, and indeed courts trying to engage with these issues in this field. And then the final point that I'm going to look at, and I can see Esther Ruppy looking slightly panicked in terms of timing, but I promise you can cut me off if you need to, is the final point I want to speak to is this question of the role of an element of argumentation in child rights and future generations litigation of growing importance. And that's this focus on the part of litigation and in turn courts on the inability of non-voting children and future generations to input into decision-making around the environment, despite being likely to bear the burden of those decisions in the long term, and the need for judicial intervention in this context. Okay, so that's the three things. Now, I'm going to start very quickly. I mean, everyone on this call is going to know that we've seen a huge explosion in the efforts to use courts to advance both born children's rights and future generations' rights in the context of environmental protection cases. And or climate justice code cases. And I'm focusing in particular in my work on constitutional rights claims. And that's because historically, much of my work is focused on constitutional law, but also because really the key decisions in this area, many of them are constitutional in nature. And we're seeing a whole range of cases globally. We're seeing cases you can see in front of you, whether it's Germany, Canada, Pakistan. We've seen in the last month, we saw the Aurora litigation begin in Sweden. Last week, we saw litigation being brought in Austria. We're seeing very exciting cases being brought in Brazil, a whole range of different jurisdictions. And I want to cite here, I think, a very helpful quote from colleagues working in this area, Parker et al., in their excellent piece in the Journal on Human Rights and the Environment, focused on child and youth-focused climate justice litigation, where they talk about the child-related body of climate change litigation as a subset of cases within this recognized rights term in climate change litigation. Okay, this phrase that we've heard used very regularly in the last few years. Now, so first of all, why? So that's what we're seeing, but why are we seeing it? Okay, so there's a whole range of reasons here. First of all, and I think this is probably the most straightforward one, we're seeing a growing awareness of the intergenerational impacts of climate change and the implications of those impacts for those at the hard end of the temporal spectrum in terms of climate change. Okay, and this is, as we understand as a society, as litigators, as people working in the area of intergenerational justice or children's rights, we're seeing an increased concern with this issue and an increased focus as a result of designing legal efforts focused on children's rights and future generations' rights. Okay, as the issues profile has gone up, so too has litigation. And from a constitutional perspective, where this is the focus of litigation efforts, we're seeing particular interest because children, in some instances, qualify as future generations for the purposes of constitutional protection or constitutional rights protection. And we see that being argued, for instance, in the Do-Hyun Kim South Korean case, where we're waiting for a decision from the South Korean Constitutional Court. And we see it being argued very effectively in the Colombian future generations case, and indeed accepted by the court without any meaningful comment on that point by the Supreme Court of Justice in its decision in that case. So that's one way in which we're seeing a coming together in constitutional law and litigation, and bringing together of children's rights and future generations' rights. And then another reason we're seeing these cases being brought is we're seeing potential for the constitutional rights of children to be leveraged to address intergenerational justice on their own terms, right? And this, I want to talk about the very exciting Austrian action that was launched last week, and I am dying inside that I've not yet been able to read the complaint, because it's a non-read document, so you can't stick it in Google Translate. Looking forward to the climate database getting that up there, Maria Antonia. But I flagged this because actually this case is fascinating from a child rights perspective, because it focuses on Article 1 of the Federal Constitutional Act on the Rights of Children, which specifies, unusually in a child rights provision, each child shall be entitled to the protection and care that is necessary for his or her well-being, to optimal development and self-realization, as well as to the protection of his or her interests with regard to intergenerational equity. That's a very interesting provision from a constitutional law perspective. It's child rights, but it captures intergenerational equity. Okay, and in many constitutions, we see reference to intergenerational equity or future generations in general provisions, but here we're seeing intergenerational equity in a child rights specific provision. Okay. Why else are we seeing these cases being brought? I mean, it's, you know, you can see it in the litigation, the fact that we can make very strong arguments about significant shared, common or mutual interest between children and future generations in the environment protection context means that children, you can make the argument, and courts are proving open to the argument, though not in all cases, that children can or should be regarded as appropriate representatives or proxies for future generations for the purposes of constitutional rights complaints. Okay, so, and this is to do with, well, actually, if we look at the proximity of children's interests and future generations' interests and the overlap, actually, we can use children as a vehicle to enforce these interests. I think there's also very important strategic reasons. The fact is, if you have child claimants in the here and now, that provides a very important face for the claims of what is potentially an abstract group, a group a group itself and whose interests may be hard for courts and for other people to conceptualize, right? But children lend a face to the problem in a very important humanizing way. Elizabeth Donger, in her excellent piece that came out last year, also makes the point that having children as claimants can mitigate the potential unintended implications for reproductive rights that might happen if we start if you focus on, as a freestanding group, as yet unborn or not yet existing future generations. That's a really important strategic point. Those of us working in the field rarely wish to undermine reproductive autonomy as a side effect of advancing children and future generations' rights. But I think it's also important to point out, and this is drawing on research that I've done with colleagues around the Advancing Child Rights Strategic Litigation Project, that the fact is the reason we're also seeing litigation in this area is because we're seeing a huge increase and enthusiasm on the part of climate justice litigators for involving child plaintiffs. Okay. And that is, of course, the legal argumentation, the fact you have the potential of child-specific rights protections, but you also have, and let me be clear, I'm not suggesting that these are not good faith strategic litigation efforts, but the fact is you also benefit from public sympathy and the support invoked by children as a social group that simply doesn't apply to other groups that may not apply to other groups that on whose behalf climate justice litigation can be brought. Okay, and that shouldn't be underestimated. It's not just about legal argumentation. And of course, a very important reason, and one that I think everyone on this panel, I'm sure in this room, would be entirely supportive of, is we're seeing children themselves are profoundly concerned about not just their own situation, but that of future generations. And as we see litigators working ever more closely and effectively and respectfully with children and young people in the context of litigation, we're seeing that being pushed forward, and that naturally gets pushed forward onto litigators' agendas. Okay, so that's a positive thing. It's something driven by children and youth themselves. So those are some of the key reasons. I'm sure you could take issue with those. I welcome comments in the Q&A. And I also welcome I know there's other reasons out there, but for me, these are the ones that seem most pressing. Now, let's see if I can change slides, which seems to have stopped. Okay, so what have we seen, right? So when we see in addressing the impact of harm to the environment on born children and unborn or existing future generations, and let me be clear, in this presentation, I use unborn and not yet existing interchangeably, but in fact, I will be using the term not yet existing in the paper, simply to move away again from this issue of unborn and reproductive rights, which has been flagged quite rightly by people talking about unborn future generations. But what have we seen happening, right? So we've seen litigation and adjudication dealing with, both in isolation and in tandem, the short-term impacts of environmental harm on the rights of existing children in the here and now, the longer-term impacts of environmental harms on the rights of existing children as future adults, and these are sometimes called already born or existing future generations, or the impacts of environmental harm on the rights of not yet existing future generations, okay? And the reason we're seeing this is that it reflects the diversity of ways in which these claims have been brought, okay? Right, so that's the fact. We're seeing these. How you bring claims depends on the group you're looking at. It depends on your legal schema. It depends on your strategy. It depends on the climate justice area you're looking at. All of this shapes this, right? But there is another reason as well, and I just want to turn to that very briefly, okay? And that is the challenge of definition, okay? And we had a very successful meeting hosted by a UCC colleague, Aoife Daly, in this area, where I spoke further about this. But I do want to bring it up here again, because I think it's important, because we are looking at a situation where there is a frequent failure of constitutions or courts to define precisely what a future generation is for the purposes of constitutional protection. Okay, the terms are used or they're not used. They might be used expressly, or their future generations' rights are implied. But it isn't always clear. In fact, it frequently isn't clear to whom the rights adhere and or who is entitled to assert those rights, whether on their own behalf or the behalf of others, okay? And the extent to which born children in the here and now overlap with future generations for the purposes of constitutional rights protection, okay? And basically, do children qualify for rights on the basis or status of their membership of two groups, as children in the here and now, and or as adults in the future, and indeed there could be a third one here, as existing future, exist as future generations per se. And that's missing from the slide, but should be there. It isn't helped by the fact that this is an underexplored issue in constitutional scholarship. It isn't helped by the fact that where we see the relative, still very limited literature of the fact, with this amazing work on intergenerational justice and equity, this wonderful literature, but it doesn't address children very much. And when it doesn't engage with the relationship between children and future generations' legal rights, or indeed children and future generations in a very effective or consistent way a lot of the time. Okay, so we're not getting a clear answer from these bodies of work as they stand. The final problem we face, and this is something, I have a link in the slide here to a blog focusing on this, a final problem we face is that international human rights law as it stands doesn't assist very much. We can at this point say with confidence that children's rights adhere to anyone, or can generally be understood to adhere to anyone under the age of 18, right? It is much less clear under international human rights law who future generations are for the purposes of definition under international human rights law, and also the extent to which they're accorded rights under international human rights law. And there's a very, very live discussion around this. We will have the Maastricht Principles on the Human Rights of Future Generations, I think, coming out in 2 weeks. And I don't want to go down that road, but I think we should be clear that this matters because actually international human rights law has been incredibly important and I know Maria Antonia will talk about Saatchi later. It has been such an important source when we're talking about detailing the constitutional rights of children The CRC has, the Convention on the Rights of the Child has been so important. And this ambiguity around and silence around future generations means that there's very little help from international human rights law, and it's a gap. Okay, so anyway, and the trouble with this, of course, we're talking about litigation, is that this lack of clarity with regards to future generations definition and the relation, and resultantly the relationship between future generations and children, it's reflected in legal argumentation and in judgments. Okay, and so for instance, when we think about, and litigants, I'm thinking now of discussions I've been involved in as part of the CRISL project around, for instance, making arguments about birth cohort discrimination. It has been a challenge. It is a challenge to litigators to make arguments around standing and who should qualify as have standing to exercise future generations' rights. This lack of clarity makes it challenging for litigators dealing with these issues before the courts. And so it's really important that we move towards answering these problems, or developing, litigators move towards answering these problems or developing issues here. Okay, now I want to turn to my third point. And this is a particular area of argumentation in climate litigation cases. Now, as I mentioned at the outset, the inability of non-voting, as yet non-voting born children and future generations, whether already existing or not yet existing, the inability of these groups to input into decision-making around the environment, despite having to bear the burden of that decision-making, is an ever greater element, more prominent theme in child and youth focused and driven advocacy and litigation, right? You see child and youth movements speaking about it in their advocacy, you see lawyers arguing about it. A very interesting example is Matur, where we're waiting for the decision in Ontario, where here the child and youth plaintiffs are concerned about Ontario's failure to set a more stringent target for the reduction of greenhouse gas emissions and a plan for combating climate change. And amongst other things, the plaintiffs assert that the target violated Section 15 of the Canadian Charter on Rights and Freedoms on Equality Rights, because Ontario's youth, including children and future generations, are, and I quote, a uniquely vulnerable population by virtue of their age, and for some, their inability to influence political decisions at the ballot box. Okay, and this is just one of many examples. All of the work I'm presenting here forms part of a working paper, the citation of which I have at the end of the article. And there's an awful lot more where that came from. But Matur is a particularly interesting example. However, despite the increasing frequency of such arguments, judicial attitudes towards the lack of political voice for children and future generations, and relatedly, judicial understandings of the potential implications of those groups positioned outside society, outside democracy, for the scope of constitutionally enforced, court-enforced constitutional constraints varies widely. Okay. Courts are dealing with this differently. They're according different weight to this issue, and that shapes the extent to which they are prepared to impose constitutional rights constraints on the outputs of democratic decision-making bodies. Okay, and I'm just going to give two very brief examples. First of all, there's the Neubauer case, where the court held that the German Basic Law Constitution sets limit on the leeways enjoyed in political decision-making process to determine whether environmental protections should be taken or not. And according to the court, Article 20A of the Grundgesetz, the Basic Law, environmental protection, in this provision, environmental protection is elevated to a matter of constitutional significance for two reasons. First, because the democratic political process is organized along more short-term lines based on election cycles, placing it at a structural risk of being less responsive to tackling ecological issues that need to be pursued over the long term. And second of all, because future generations, those who the court said will be most affected, have no voice of their own in shaping the current political agenda. Okay, so we see there children and future generations' location outside democracy directly feeding into judicial willingness to impose constitutional constraints. it's interesting actually, because in this case, the court focuses on the rights of future generations and what it talks about future loss of freedom, but doesn't actually talk about the constitutional rights of children as such, even though it says that they are in fact exerting their own rights in the case. So there's as a child rights person, Neubauer, while it's been greeted warmly by future generations, there are questions from a child rights perspective to be asked. But let's contrast this very positive decision overall with the approach adopted by the Norwegian Supreme Court in the Greenpeace Nordic Association case. And this case was, as everyone here will know, brought by Natura Ungdom, or Young Friends of the Earth Norway, which was a membership organization open to 13 to 25-year-olds. And the complainants based their argumentation on Article 112 of the Norwegian Constitution. And the court stressed, which talks about essentially every person has a right to an environment conducive to health and to a natural environment whose productivity and diversity are maintained. National resources shall be managed on the basis of comprehensive long-term considerations, which will safeguard this right for future generations as well. Okay, so a general constitutional rights provision with a clear intergenerational component. And the court stressed that on the one hand, consideration for the rule of law obviously indicates the court should be able to set limits, including for political majority when it comes to protecting constitutionally established values. On the other hand, this is where it gets interesting, decisions in cases regarding fundamental environmental issues often involve political balancing and broader prioritization. And democratic considerations therefore support such decisions being taken by popularly elected bodies and not by the courts. Okay, and as such, for the courts to set aside a legislative decision by Parliament, that body would have to have grossly disregarded its duties to take measures for the implementation of this principle in terms of the constitutional framework. Okay, so no attention paid to the location of children or future generations outside the democratic decision-making processes that the court makes reference to in glowing terms, nor is there engagement with the substantive content of children's rights. Okay, so you see very, very different approaches on the part of these two courts, okay? And the Colombian decision is also interesting, but I won't go into it for time. But so why should we look at this? Why does it matter what the courts do around democracy, okay? Well, the reason for this is there are two key related elements of democratic theory and liberal constitutional theory that are often presented as objections to the enforcement of children and future generations' rights, as we've just seen in the Norwegian case, in the context also of environmental protection. And these are the bread and butter of climate justice decision-making in many instances. The separation of powers doctrine and the counter-majoritarian argument. Separation of powers doctrine, we'll all be familiar with the idea that there are three branches of government and each of these branches has discrete functions. Okay? There's lots of different understandings of the separation of powers, but from the perspective of a narrow, formless conception of the separation of powers that we see in some climate justice cases, the idea is the courts shouldn't encroach on or become involved in or even constrain the law or policy-making functions of the elected branches of government. The counter-majoritarian objection, as outlined by Alexander Bickel, is that when a court invalidates a legislative act or the action of an elected executive, it thwarts the will of representatives of the actual people in the here and now. It exercises control not on behalf of the prevailing majority, but against it. And the key thing for us, and the reason we have to pay attention, is that these very important elements of liberal constitutional theory, which are posited against judicial intervention in many of these cases, are underpinned by specific understandings of the respective roles of courts and the elected branches of government with regards to enforcing rights. Okay? And in particular, they're based on presumptions about the legitimacy and appropriateness of particular mechanisms, particularly majoritarian decision-making mechanisms, democratic mechanisms for the resolution of disagreement about rights. And they also often implicitly reflect assumptions about the location of rights bearers with regards to democratic decision-making, and they reflect assumptions about the capacity of rights bearers to employ majoritarian democratic decisions. And most importantly, they assume the effective representation of rights bearers' interests in democracy, whether through voting or other forms of representation. Okay, so these are part and parcel, right? But of course, the challenge is that these assumptions are assumptions. and they don't hold true for children, and they don't hold true for future generations. Now, and I don't have time to get into this, but it's a key part of the paper and work that I've done previously. Children of future generations, they don't vote, and nor do they exert meaningful indirect influence on majoritarian decision-making processes. And that's because there is a failure on the part of those who do directly participate, whether parents, adult society generally, politicians, to effectively represent children's and future generations' views and interests. And my argument is that as a result, courts need to look very carefully at the social, political, and economic position of groups that come before them. And where it is clear that groups neither directly participate in nor are effectively represented in democratic decision-making processes that are generally regarded in liberal constitutional theory as the vehicles by which such rights are delivered, well, then the courts need to intervene to ensure that these rights are secured. Okay, and in doing so, if you have a situation where the courts ignore this, you ultimately have the courts failing to serve as guardians of rights under the separation of powers and under constitutional, in the context of, and in terms of liberal constitutional theory, and that matters hugely. So that all sounds good, and I promise I am finishing Asterope. And I can see the other speakers going, shut up, which is fair enough at this point, sorry. But I just want to finish. I want to turn back to some of the issues I raised earlier in order to raise a few flags for litigators moving forward in this area, making this kind of argument. First of all, I've already flagged the issue of definition, okay? And the challenges that poses to both litigators and to courts working in this space. However, even leaving the definitional issue aside, and it's really hard to do it because you spent a lot of time in these cases on it, it is clear that the rights of existing children focused on the here and now may raise different issues with regards to citizenship, different forms of representation, and the legitimate scope of judicial decision-making or majoritarian decision-making than is the case for future generations. Okay? That is the case for then is the case with regards to the, when we're looking at the situation of future rights claims of existing children as future adults and the rights of not yet existing future generations. Okay, the fact is, it cannot be, these raise different issues. These groups are differently represented, they're differently accommodated, there's different issues at play there when we think about how the assumptions that underpin the separation of powers and the counter-majoritarian objection are affected. And nor, of course, can it be assumed that the interests of existing children as future generations and the interests of not yet existing future generations will necessarily be consistent, okay? So, I mean, if we think about the budgetary decision, we can think about a situation where budgetary decisions taken to secure climate justice for future generations impact negatively on the rights of children in the here and now, right? And in terms that raises questions about the respective inclusion and democracy of the two groups. And finally, there is the issue of indeterminacy, right? Where you're talking about the rights of children or the rights of future generation or the future enjoyment of rights of existing children as adults, indeterminacy, there's always an element of uncertainty at play. And this uncertainty necessarily complicates the balance to be struck between the constitutional rights of children and future generations' rights, okay? And where these issues arise, courts have to acknowledge, and litigators need to present convincing arguments to courts dealing with these indeterminacies and conflicts and address them with enormous care. It won't work simply to cover them because it will be an excuse for courts to step back and say, that's arbitrary, you're not adequately defining groups, you're not making arguments that are coherent and consistent that I can apply in other cases, and it will be a problem. It isn't a case of one size fits all for a judicial approach, but nor should it be a case of one size fits all when it comes to climate justice litigators' efforts with regards to children's rights and future generations' rights. Thanks very much.
Thank you so much, Ika, for this fascinating presentation. I'm sure we will have many questions from the audience. For now, I would like to introduce Dr. Maria Antonia Tigre, who will speak second. Maria Antonia is the Global Climate Litigation Fellow at Sabin Center. And prior to this, he was a senior attorney at the Environment Program of the Cyrus Vance Center for International Justice, working at the intersection of human rights and the environment. Maria Antonia was previously a fellow at the World Resources Institute, and she's serving now as the Deputy Director of the Global Network for Human Rights and the Environment. She's also an adjunct professor at the Elizabeth Hope School of Law, and in her research, she specifically focuses on issues concerning environmental rights, the reshaping of the existing framework of international environmental law, and climate litigation. Maria Antonia, the floor is yours.
Thank you so much, Esteropi. I'll share my screen as well, as I have a couple of slides to show. It's a huge pleasure for me to actually be talking about this topic, because it's a topic that's very dear to my heart. I've been doing a lot of work both on behalf of the Sabin Center and on behalf of GNHRE on children's rights, and I really find this fascinating, even though I'm not like Aoife, a child's rights expert at all. My focus is more generally on human rights and the environment, and then obviously on climate litigation as a whole. But I've spent some time looking at the Saatchi case, and I'll focus a little bit on that due to its importance for children's related climate litigation and sort of future effects that it can have on global climate litigation as well. So this case was brought as a complaint to the Committee on the Rights of the Child in 2019 by 16 children from 12 different countries. And this was brought against 5 countries: Argentina, Brazil, France, Germany, and Turkey. They chose G20 countries that obviously were part of the convention. So that's sort of part of the reason why these countries were chosen. But obviously, the defendants are from other countries as well, not only limited to the ones from the respondent states. And it's one of the few cases that have relied specifically on children's rights, focusing on children as recipients of rights and the need to rely on their best interest principles. So that's why it's a good example to sort of understand how children's related climate litigation has been occurring, and then thinking about the future as well, and sort of how that can evolve. So, just as a brief timeline. So like I said, the petition was filed in 2019, and it was dismissed in 2021. So I'll talk a little bit about why it was dismissed and why this case is still very much relevant for that further development. But a couple of important things happened after this, which I think are also worth mentioning. So the Committee on the Rights of the Child decided to proceed to develop a general comment on children's rights and climate change, which is an ongoing process. There's a draft 0 available, and I think it's very much shaped by this petition as well, and trying to have that focus despite this dismissal. And then another thing that happened afterwards is that the same children filed a petition to the Secretary General at the United Nations, asking the Secretary General to declare climate change to declare a climate emergency, which is a process that will likely not result in much, but it was still sort of significant as a response to that and another resorts to it. So what have these children said in this petition? So the allegations were that the states had failed to respect their obligations under the convention due to obligations to prevent foreseeable domestic and extraterritorial human rights violations from climate change by reducing their emissions, the obligation to cooperate internationally to combat the climate crisis, apply the precautionary principle to protect life in the face of uncertainty, and ensure intergenerational justice for children. And in terms of the requests, they requested the CRC to find, in terms of a declaration of breach, that climate change is a children's rights crisis, that states have caused and perpetuated the crisis by disregarding scientific evidence on prevention and mitigation, and violation of specific rights under the CRC. And these are the rights to life, the best interests of the child, the right to health, and then with respect to certain petitioners that are from indigenous communities, the cultural rights as well. And in addition, there were a couple of requests that relate to cessation of a breach and guarantees of non-repetition. So sort of, more intentionally forward-looking as well. And these were to review and amend their laws and policies to ensure concrete mitigation and adaptation efforts that make the best interest of the child the primary consideration, establish international cooperation towards binding and enforceable measures to mitigate the climate crisis, and ensure the child's rights to be heard in the context of the climate crisis as well. In terms of the remedies, the exhaustion of domestic remedies. So this was a core issue of the case because these children went directly to the CRC without first filing cases under their domestic jurisdiction, their national jurisdictions. That's very important because usually these international courts and tribunals and quasi-judicial bodies do have this request, this procedural requirement to actually exhaust domestic remedies first. And these petitioners asked for an exception to the rule for a couple of different reasons. The first one is that they said that the implementation of domestic remedies would be very long, would take too long, and would unlikely bring an effective relief. Considering that there are 12 children from 12 different countries, they would likely need to go through 12 different court systems. It would take a long time, and until we eventually had a result, it would be too long. And they also argued that states would have used foreign state immunity to bar domestic claims against the others involved. So with respect to that extra territorial application as well. And also said that only the CRC could secure preventive measures from states within the limited time left to avoid the irreversible tipping points of global warming. Obviously, the states responded to this by saying that the petitioners should have brought the case before domestic courts. And it was this reason specifically that led to this case being dismissed. An important statement from Belinda Walzer with respect to what they're looking for here is that the argument that they are making is in multiple temporalities. They're saying that the states are violating the right to futurity now, and that they will be violating future rights if they don't act now. I really like this quote because of that temporality aspect, and I think it helps sort of think about that timing issue that is central to this case. So, like I said, the CRC eventually dismissed the petition. They said that they didn't exhaust domestic remedies or even tried to initiate them without concrete explanations as to why. The committee said that mere doubts or assumptions about the prospects of success or effectiveness of remedies did not exempt petitioners from exhausting them, and that when children have no access to justice, or if their complaints are not dealt with properly, then the case can be brought to the CRC. So they also responded with sort of a model on how that could potentially be successful in the future. There was a big risk if the CRC had accepted the case that it would become a tribunal of first instance of preference, and that could have also undermined national efforts to hold states accountable for insufficient climate action. So that's partly why they dismissed it as well and didn't try to change or give exceptions to some of these rules. But despite this dismissal, obviously the petitioners were very sad and hurt by that decision. But I still think, in some other legal scholars as well, that it was still very significant from, obviously disengaging a little bit from that personal angle of the case, but thinking from a legal perspective, I still think it was very important. The committee has made several important statements on climate litigation, specifically related to children and how successful cases could be brought, and also defining some of the legal obligations and standards that apply to them. So the first one was that the potential harm of states' acts or emissions on greenhouse gas emissions was reasonably foreseeable. That's pretty significant, saying basically that some of the causality challenges, the challenges that usually are part of certain climate litigation cases can be not as hard to be met because of that foreseeability that was explained by the court, by all of the scientific evidence that is already available. The second one was that states' greenhouse gas emissions actively contribute to climate change, and that contribution is not limited to states' boundaries. So also one important recognition, which is something that obviously from a scientific perspective we've known for a while, and some other courts at national level have also said, but important for the committee, as that state of as a UN body to also be able to define that and clarify that. And the third one was that petitioners have established that the violation of human rights was reasonably foreseeable and that they have personally experienced significant harm. So also the arguments that they had made there was significant, it was sufficient to establish that. So, I wanted to talk a little bit more about this issue of extraterritorial jurisdiction, which was defined by the committee, which I think was one of the big important statements that the committee has made. As a sort of factual problem, obviously greenhouse gas emissions of one state produce effects worldwide, and there are significant legal challenges and limitations to establishing that and then seeking that access to justice to remedy this. The legal problem here is that to vindicate human rights violations by a foreign state before international human rights judicial bodies, it must be proven that states generally have obligations to prevent climate change caused to individuals outside of their territory. There have been very few cases attempting that, and most of them are actually still pending. So extraterritorial jurisdiction is exceptional and must be established. And what this could potentially mean is that expansion of people being authorized to litigate on the international stage. So the states, what the committee eventually said, so basically in general, states have extraterritorial jurisdiction over harms caused by greenhouse gas emission. And the committee relied a lot on a previous interpretation that was done by the Inter-American Court of Human Rights on an advisory opinion on human rights and the environment, which I have written quite a lot about. I can send in the chat some of those resources, but basically saying that the jurisdiction extends to individuals outside of a state's territory who are harmed from foreseeable transboundary environmental damage. So states must address climate harm outside of its territory and are liable for the negative impacts of their emissions on the rights of children located both within and outside of their territory. And the committee also said that it's generally accepted that greenhouse gas emissions contribute to climate change and that climate change has an adverse effect on individuals beyond any emitter's territory. So, looking more specifically on the legal requirements for that and how, what's the legal reasoning, what the test is moving forward, the committee adopted this effective control test, which was previously brought by the Inter-American Court of Human Rights as specifically relates to transboundary environmental harm. So there's an expanded interpretation of what control means in this case. In general, saying that when acts of or emissions are sufficiently connected to the violation, so not only within the specific territories, but where they have effective control, the victims are considered to be within the state's jurisdiction. So there are specific issues here of directness and foreseeability as well that I'll talk about. So this causality nexus is important and a key piece of this. Because it says that these victims of transboundary environmental harm are under the human rights jurisdictions of states emitting greenhouse gases if there's a causal link between the act originating greenhouse gas emissions in its territory and the human rights infringement of persons outside of its territory, and then the foreseeability of victims' harms as a consequence of the emissions allowed by states. And finally, the ability to prevent that transboundary harm. So if there is this link, if states have known about this before, which at this point we can agree that everyone knows about it, all states know about it, and they have an ability to prevent that transboundary harm, which again, most of them can, because most of them do, then that causality link can be established. So in respect to that foreseeability of harm aspect, just wanted to mention a couple of different things. So the potential harm of states' acts or omission regarding greenhouse gas emissions was reasonably foreseen, and because it's generally accepted and corroborated by scientific evidence that, greenhouse gas emissions contribute to that harm, and specifically human rights harms as well. And there's a sufficient causal link, again, to establish jurisdictions. They have sufficiently justified that the violations of their rights under the CRC are a result of the state's carbon emissions, was reasonably foreseeable, and justified their victim status by establishing that they have personally experienced significant harm. And I'll talk a little bit more about this victimhood aspect now. So according to the protocol that defines the procedural requirements to bring these communications, it says that the communications may be submitted by an individual or group claiming to be a victim of a violation by a state party of rights under the CRC. Victims are defined as persons who individually or collectively have suffered harm through gross violations of human rights law. And it's generally understood that the applicants have the burden of proof to establish that, which is a significant challenge in climate cases because they can't bring that general interpretation of harm there, of being a victim, and then in UN treaty bodies because there's no collective complaint procedure as well. So the interpretation of the CRC was very significant because they did recognize that the petitioners personally experienced a real and significant harm in order to justify their victim status. So there was a flexibility in interpretive victimhood here, and then that could eventually be precedent setting for victims of climate-based human rights violations. So obviously not only for the CRC, but then at the domestic level, for example, at the European Court of Human Rights, this issue of victimhood, the pending cases, they very much touch on this. There will be hearings at the end of this month discussing this. So this could potentially influence that as well. So what is the significance of all of this for future cases, right? So why is this important? A lot of it is procedural, so not specifically relating to rights, but on this issue of access to justice and how certain procedural requirements could be a little more interpreted a little more flexibly to actually allow for children to bring certain cases. So it is the first case to hold multiple states parties responsible for human rights violations related to climate change. Even though the case was dismissed, that was a significant statement that there was a violation here and recognizing them as victims. Then children are now considered under the jurisdiction of the state where the emissions originated if the state exercises effective control over the sources of the emissions at issue and has knowledge of the risk of wrongful effects, and if there is a causal link between states' acts or emissions and their harmful impact on children. And also the collective nature of causes of the climate crisis does not relieve states of their responsibility to mitigate emissions originating within their territory to avoid their adverse effects on children wherever they might reside. So, all of that really makes this maybe not groundbreaking from certain legal aspects, but definitely significant for future climate litigation. And lastly, I just want to briefly mention this process of the general comment, which is ongoing, and how that is sort of placed within some other significant developments in international human rights and the environment law. So as some of you probably know about this already, but I just wanted to flag how these developments have both responded to some of these cases and also will significantly affect them moving forward as well. So in 2020, there was a resolution from the Human Rights Council on realizing the rights of children through a healthy environment. Then specifically that evolved to actually a resolution from the Human Rights Council on the right to a healthy environment specifically, so adopting that at an international level, which then called on the General Assembly to also recognize it, and that happened last year. And then now we have this general comment from the CRC being produced, and that's likely going to be adopted by the end of the year. So, that all really can shape the way that climate litigation relating children is evolving, and hopefully strengthen that significantly. And finally, the last thing that I wanted to mention, just responding to some of the comments that Aoife has made on this lack of definition on future generations, just wanted to mention, obviously, I think all of you have heard of these different advisory opinion requests that have been filed recently. And two of them actually touch on future generations specifically. So the Inter-American Court of Human Rights request specifically relates to that. So I think there's a possibility that the court will potentially engage with that definitional issue. And then the ICJ one also specifically touches on future generations. So hopefully we'll see some of that movement there in both of them. And there's also the possibility, at least at the Inter-American Court, to send amicus briefs that could potentially also, push the courts to actually define that. So just wanted to flag this too. So I'm happy to discuss more. And yeah, thank you.
Thank you so much, Maria Antonia, for this amazing presentation and all the interesting points that you've raised. I very much look forward to the Q&A discussion later. Now, we live in a century that has been characterized by the legal disruption that climate change brings, but also it has been characterized as the century of climate migration. So billions of people are expected to be forcibly displaced. And of course, the first contact will be for them to be in refugee camps. And this will happen not in the future, but it's happening right now. So of course, all these consequences of climate change will affect children's rights, including the right to food and all the rights associated with their well-being. So I am delighted that we have with us Alicia, who will talk on the issue broadly. Alicia is a PhD candidate and family law associate lecturer at UCL Faculty of Laws and a lecturer at Sciences Po in Paris, where she convenes the model Gender International Human Rights Law. Her PhD research focuses on gender equality as a matter of international human rights law, with a focus on structural inequality, domestic abuse, and economic violence. Alicia researches and writes on the complexities of coercive control, post-separation abuse, and the intersection between the rights of women and children. And her research is supported by the UCL Faculty of Law's Research Scholarship, the UCL Joseph Hume Scholarship, and the Modern Law Review Scholarship. Last September, Alicia was also appointed as Senior Policy Advisor to the Domestic Abuse Commissioner of England and Wales. Alicia, thank you so much for joining. The floor is yours. You are on mute.
We'll just load up my slides. Can I double check that that's visible? Wonderful. Thank you so much for having me here today, and for the very kind introduction, Asteropi. Thank you to the Sabin Center at Columbia Law School for organizing and hosting this event, and to Maria Antonia and Asteropi for moderating and making sure that everything goes very smoothly. So, as Asteropi has said, I am a family law associate lecturer, and my doctoral research focuses on gender and the law. And the research that I'll be presenting today, I suppose, annexes to the concept of children refugees as a result of climate change, and considers quite specifically the existing legal framework, which provides that infrastructure in relation to children and their access to food and nutrition in refugee camps. So my research is empirically informed from interviews conducted in France, Greece, Iraq, and the UK. And I will give an overview of my presentation. So my research looks to outline the framework within which women who choose and wish to breastfeed are enabled and supported to do so under international human rights law. My research considers the same category of women within the specific context of refugee camps, including climate change refugees. And in refugee camps, resources, both physical and human, in terms of specialized breastfeeding support, are limited, unreliable, and dependent on other factors for delivery. So I will present my research in 5 stages, firstly looking at breastfeeding as the optimal form of infant feeding. I will then move on to consider formula milk as an alternative to breast milk, and then assess the relevant legal provisions on infant feeding. I'll then turn to my empirical research before concluding, and as part of my conclusion, I will offer a structure of ideal practice which advocates for protecting, promoting, and supporting breastfeeding in refugee camps. So looking at breastfeeding, its benefits and mechanism now, the health debates which surround infant milk consumption are long-standing, and the benefits of both breast milk and breastfeeding have been established and recognized as universal among all mothers and children. Breast milk offers unrivaled health benefits to a child. It is a near perfect diet, owing to a unique composition of vitamins and minerals. Breast milk also contains a number of antibodies which protect children from infection, long-term ill health and death, and has no hygiene requirements to administer safely. Breastfeeding has been referred to as the ultimate natural vaccine for babies. Technically, it's also free, but that's only if we assign the time that's spent breastfeeding as being of no monetary value. But there are no price tags attached to breastfeeding in that sense. Breastfeeding also has a positive health impact on mothers, both immediately after childbirth and later on in life. It reduces maternal bleeding after childbirth and delays ovulation, which means the conception of subsequent children can be delayed, reducing strain on the mother's body, which is of considerable benefit when contraception isn't accessible, such as in refugee camps. And continuing breastfeeding also reduces the risk of type 2 diabetes, cardiovascular issues, breast cancer, and other health complications. And the psychological postpartum benefits of breastfeeding have been well documented and include an improved mental state of the mother. As to the mechanics of breastfeeding, breastfeeding works on the basis of a supply and demand mechanism. Milk production is the supply and is stimulated by baby nursing, which is demand. So unhindered access to nursing sends the clearest and most accurate message of need to the mother's body to produce the correct amount of milk. And in order to calibrate the correct supply to demand, introducing formula milk is not advised, as it interferes and corrupts with the communication loop between mother and child. So the alternative to breast milk is formula milk, which is normally based on processed skimmed cow's milk and is presented as a powder, which is then combined with boiling water to kill any potential pathogens in the powder to produce formula milk. Now, the cost of formula milk is estimated to be in excess of $1,500 for the first year of life, dependent on the brand. And this excludes the cost of equipment, which is needed to administer formula milk. Now, with respect to formula milk's background, in the 1930s and throughout the 1970s, aggressive marketing campaigns and approaches were used by formula milk companies in the global south. The benefits of formula milk were exaggerated and in instances completely fabricated. So a wide range of unpalatable formula milk selling tactics were directed at women from economically developing countries, including the use of saleswomen dressed as nurses in maternity wards, who advised the use of formula milk over breastfeeding, implying that the hospital and healthcare providers favored formula feeding over breastfeeding. And labels stating made in Europe also implied advancement in the design and manufacture of the product and introduced a racial dynamic, which exacerbated the issue. And sale tactics used images such as plump white babies to portray to mothers that wealthier women in more stable and economically developed countries formula fed their children as they had the funds to afford the product, and women felt compelled to resort to formula feeding in order to provide their babies with nutrients which they were told their bodies would not provide hours after giving birth. And the aggressive marketing tactics generated billions of dollars of profit and significantly contributed to the global decline in breastfeeding. And it was against this backdrop that the International Code of Marketing on Breast Milk Substitutes was passed in 1981 to regulate formula milk marketing on a global level. The code prohibits the use of pictures and texts which idealize the use of breast milk substitutes, but they can still be legally marketed, sold, and used. But quite simply, the code takes a confrontational approach to the style of marketing campaigns utilized by formula milk companies. Now, reinforcing these provisions is the Innocenti Declaration of 1990, which committed governments, firstly, to ensure maternity services uniformly provided breastfeeding services, Secondly, compelled states to take action to effect the 1981 Code's provisions. And lastly, and crucially, to enact legislation on a domestic basis to protect breastfeeding rights of women. And whilst the Code and Innocenti Declaration are non-binding, they are strongly persuasive as instruments of soft law. So turning now to hard human rights law, which is legally binding on state parties, the International Covenant on Economic, Social and Cultural Rights, 1976, in Article 11, recognizes the right to adequate food as a prerequisite to realizing an adequate standard of living. Article 12 then establishes the right to the highest attainable standard of physical and mental health. And the article makes particular reference to the reduction of infant mortality for the healthy development of the child. Now, considering infant feeding at this juncture, given that formula milk seeks to mimic breast milk and replicate its health benefits as closely as possible, it can quite clearly be reasoned that the physical health protection of breast milk is unparalleled to any other form of infant feeding, and is subsequently a means of realizing Article 12. And reading the two articles in a combined manner is a rational and reasonable interpretation of the Covenant, and indeed of international human rights law as a whole. The human rights legal framework seeks to establish an infrastructure where human rights intersect and give rise to a multitude of protections in order to provide the maximum amount of security for the individual. Within the context of infant feeding, not only should Articles 11 and 12 be read together legally, but logically, they have to be read together because successful breastfeeding and optimal nutrition are inseparable when it comes to children. And this is very much underpinned by the fact that breastfeeding has the potential to prevent the deaths of over 860,000 children under the age of 5 if globally all children were breastfed from birth. So the Convention on the Elimination of Discrimination Against Women, 1979, outlines binding provisions on health and requires state parties to ensure to women appropriate services in connection with pregnancy and the postnatal period, as well as safeguarding adequate nutrition during pregnancy and lactation. Derogations from the Convention are prohibited, and state parties are responsible for their own actions, in addition to those perpetuated and undertaken by private individuals and organizations. And the Convention also clearly acknowledges that the health needs of female refugees in camps are the most frequently neglected. And finally, as we've been speaking about quite a lot today, the Convention on the Rights of the Child, 1989, which seeks to provide a strong and non-negotiable level of protection for children. And the rights within the Convention apply in full to children in refugee camps and on forced migratory journeys, including those prompted by climate crisis. The Convention recognizes that the primary responsibility for ensuring and realizing child survival and development is with the family, and establishes the duty that governments have to create conditions which enable parents, extended families or communities to provide for children in order to obtain the protection within the Convention. And there are also breastfeeding specific provisions within the Convention, which are pioneering, and they make explicit the implied link between health and food in the International Convention on Social and Cultural Rights. So in sum, and drawing on those multiple points of international law, the right to be educated on infant feeding and supported if choosing to breastfeed exists within the international human rights law framework. So turning now to my empirical research, I was able to identify 5 broad areas of contention with respect to formula milk distribution in refugee camps. Firstly, looking at the need for appropriate water. Refugee camps routinely have inconsistent and unreliable access to clean water. And empirical interviews showed that restricted access to water was observed in the refugee camp La Linière in France, where approximately 100 men tended to congregate and smoke cigarettes around the single water tap. Now, women were therefore, understandably, reluctant to approach and would wait for men from their own families to collect water from the tap. And as a result, women were unable to make formula milk for their children when they needed it, and a bottle of formula milk could be left in high temperatures for several hours. Once formula milk is made up, it becomes a really ideal breeding ground for bacteria and needs to be consumed within an hour. And of course, the lack of refrigerators in refugee camps seriously increases the likelihood of bacterial growth and subsequently infection. And there were also accounts of women making formula milk with water from lakes and rainwater, which poses a risk of serious infection, morbidity, and mortality to children, particularly newborns. The inconsistent access to appropriate water and the significant implications are really specific to a refugee context, and they very much undermine the safety of formula feeding from the outset. So the need to obtain clean water for formula feeding also creates a risk to women who are exposed to gender-based violence and sexual assault when walking towards water sources, especially at night, as taps are normally placed away from residential areas of refugee camps. And in addition to this, the means to boil water, such as access to fuel, a stove, or wood to burn in order to create a fire, are elements which are not always available. And given newborn babies feed at least 8 times a day, unreliable access to boiling water creates an immediate obstacle to safe formula milk supply and feeding. Again, in La Niña, there are women who refrain from collecting and burning firewood for boiling water, and their reluctance actually stems from fires enabling French police to locate and evict families by destroying their sleeping bags and tents. With respect to formula milk powder availability, the substance itself is routinely supplied by aid distributors, governments, and NGOs in refugee camps. And aid delivery blockages, for any reason, can result in limited or entirely inhibited aid supply to camps, which includes formula milk. And with regard to education of formula milk feeding, my empirical research clearly showed the panic and distress faced by formula feeding families when formula milk powder was less available or unavailable entirely. And I obtained accounts of mothers responding in dangerous and ill-educated manners. And these have been the tragic cause of multiple infant deaths in refugee camps. Women in refugee camps have diluted formula milk to 1/10 of its intended and safe concentration when aid deliveries were reduced, as they misunderstood the effect of formula milk quality and attempted to create quantities of milk with which they were familiar. And clearly the quality of the milk was significantly compromised, and infants have faced both morbidity and mortality as a result. I also obtained accounts of women who, when faced with limited formula milk powder, used any white powder available as a substitute in the belief that it would sustain their children. Newborns and infants have died in refugee camps in Iraq from being fed watered down coffee creamer, maize meal and porridge, and tinned evaporated milk and sweet condensed milk, which offer no nutritional value, have been mistaken for liquid formula milk and fed to babies. And it's well documented that formula powder is sold on the refugee underground market during periods of shortage at highly inflated prices, which results in families paying disproportionate amounts of money, often sacrificing food for themselves and other older children. And refugee camps receive out-of-date formula milk donations, and that creates an immediate and serious risk. And exacerbating this is the matter of formula milk arriving from developed states with instructions in multiple European languages, but not necessarily in languages which can be understood by the refugee population. And cultural factors also come into play, and many refugee mothers have reported their reluctance to feed in front of others, including within their own tents, as brothers-in-law can be housed with them. But an issue of particular significance, and a fairly complex one, is the unfettered distribution of formula milk by those in official uniform. And the presentation of formula milk by refugee camp officials is very much seen as an endorsement of the product, and is intensified by the historical backdrop of formula milk campaigns, which I've outlined. And the concept of discrimination is introduced as refugee camps are approached entirely differently to citizen society, where formula milk advertising is largely prohibited. If a woman were to receive formula milk in a maternity hospital after giving birth, it would amount to a breach of the code. Yet aid workers are permitted to distribute formula milk to refugee mothers whilst wearing official uniforms. And despite soft law prohibiting formula milk promotion, formula milk is often one of the first aid donations to arrive in refugee camps, and therefore is inadvertently promoted by its seemingly official distribution. So continuing with empirical research findings, at a state level, refugee camps across the world share a common feature. They are always intended to be finite in existence. Their provisional and often quickly established nature is reflected in the transient setup of almost every aspect of their composition. And this approach is entrenched in anticipation and hope that the camps will be disbanded. But the reality is that some refugee camps become quasi-permanent, and they mirror citizen life. With schools, shops, and hospitals, children and grandchildren have been born in refugee camps. Camps are often overpopulated, with people living in close quarters with little privacy, and this is a global problem which is exacerbated by the fabric tent barriers commonly utilised. With respect to climate change, we're going to see huge flows of migration of individuals, and when this happens, it's very difficult to run the argument that it wasn't seen coming. Yet camps are never planned for in advance. Another part of this is that camps are really well known for extreme temperature fluctuations, something which is only going to get worse. And the crowded environment and lack of cleaning facilities mean they are often subject to disease-ridden conditions. And residents are required to queue for aid, for example, medical and administrative services, and women are routinely tasked with this responsibility. And this role clashes with the need to establish and maintain breastfeeding. And beyond the physical parameters of the refugee camp itself, but still looking at the entirety of a migrant parent holistically, breastfeeding a child allows for feeding continuation in the event a mother continues to migrate with her child or is forced to relocate quickly. During interviews, a Yazidi woman who fled from her home village following an attack by jihadist military group Daesh hid in a mountainous area with her 2-year-old child for 10 days. She was without food for this entire period, and she arrived in a refugee camp in Iraq. And she very simply said, "If I was not breastfeeding him, my son would have died." So my research conclusion centers on the role of a child's caregiver's need to be empowered to realize the child's rights, which are afforded by the International Human Rights Law framework, but are regularly breached in reality. So within the specific matter of breastfeeding, mother and child are a dyad. A child's rights can only be realized if the mother is able to realize them on her child's behalf. And there is a clear intersect in refugee camps, and the need to interlock the multiple components of the circumstances with the broader International Human Rights Law framework is evident. So in concluding, what would best practice look like? So having identified the legal and practical issues, what would optimum practice be? Well, firstly, controlled distribution of formula milk should be implemented rather than the present practice of unregulated distribution. And formula milk should be allocated to mothers who wish to formula feed at any stage, because maternal autonomy is key. There is by no means any requirement. There's no human right to breastfeed or to be breastfed, but it is an exercise of maternal autonomy. And for formula milk supply to be beneficial to mothers and babies, it has to be effective, and therefore it has to be provided in adequate quantities, be of adequate quality, and be supplied with the necessary apparatus for safe consumption. This also means that appropriate guidance has to be delivered with comprehensive instructions on how to prepare formula milk. And direction should ideally come within the form of training. And this is also really important, that control distribution element means that if there is a lack of formula milk availability, formula-fed babies can be identified at the outset and approached in a way that's appropriate. There also, on a social level, needs to be work to move away from bottle association with newborns and infants, which is direct and continued historical hangover from aggressive marketing campaigns. And many public spaces in economically developed countries still use bottles as images to indicate mother and baby rooms. And Brazil, as an initiative to encourage breastfeeding, instigated a campaign both to normalize and to promote breastfeeding by conveying positive messages and imagery in a systematic way through soap operas, on lottery tickets, and on bank statements with considerable success. Crucially, camp officials must scrutinise the perceptions created by the distribution of formula milk to refugee mothers from economically developing states. And on a practical level, women in refugee camps require access to support services and expertise in the same fashion citizen women in hospitals do. And support services should be provided by the state, be free, and those providing support and expertise should be trained appropriately and be aware of their obligations under international human rights law and the relevant soft law provisions. And furthermore, support should be provided at the outset, as the likelihood of successful breastfeeding increases with early establishment, and should be readily available in refugee camps and continue onto temporary accommodation when mothers and children are housed. And mothers should be engaged with, empowered, and educated. The composition of camps also needs to be addressed, so separate fast-track queues for breastfeeding mothers should be established, or appropriate spaces next to queues should be created so that mothers with infants can leave and return to fulfill their tasks. But ideally, mothers with young children, and especially breastfeeding mothers, should not have to queue for services at all, and instead have aid, which includes adequate and nutritional food for the breastfeeding mother herself to be delivered to her. The research has been published in the Human Rights Law Review, and I would be very happy to answer any questions in the question and answer session.
Thank you very much, Alicia. There is a lot of discussion on what is going to happen when millions and millions of people will be displaced, and on the very meaning of what a climate refugee is, especially after the decision of the Human Rights Committee in Titiona. So I am sure that we will have a lot to explore in this research. Now, last but not least, I want to introduce Kata Doza, who is a postdoctoral research associate in the Law and Development Research Group at University of Adverb Law Faculty. Her research interests include areas of environmental and climate change law linked to human rights, and in particular on children's rights. She holds a master's in law and in journalism, as well as an advanced master's of children's rights from the University of Freiburg and Institute of Kurt Bosch. She had worked for the European Commission as Press Officer for Climate Action and later as Policy Officer for the Rights of the Child. Her doctoral research focused on environmental citizenship of children and the right to public participation in climate change governance. As a postdoctoral researcher, she seeks to explore how children's access or the lack of access to various public spaces of participation in climate change matters and inform and shape their citizenship status and practices. Kata, thank you so much for joining. The floor is yours.
Thank you very much, Astropi, and Maria Antonia for making this event a reality, and very nice to meet all of you. So I will share my screen and start my presentation. Yeah. Do you see the slide?
We do. If you could enlarge them slightly by clicking the presentation. Yep.
I just one moment. Okay, so it's quite slow. Sorry. Okay. So the intergenerational burden. Children as representatives of future generations in strategic climate change litigation. So what I will do is that I will try to provide a bit of a critical angle to both the social and the legal implications to what representation of future generations by children in climate change litigation holds. And to that end, I brought 3 cases which will show how intergenerational rights are advanced through children, and how children as plaintiffs play a key role for representing future generations. I will compare these three cases because they have very common features and also some different points, and we'll show you these differences. And then I will discuss what strategic climate litigation has as core elements for intergenerational implications. And then I will provide some insights to the intergenerational implications from a critical approach. So basically pros and cons from a legal and from a social point of view, including children's perspectives or children's ideas about what representing future generations means. And then I also brought some fruitful thoughts for alternative solutions for representing future generations in climate change litigation. So, sorry, just I'm also struggling with having my notes open. Okay, now I'm there, and then okay. So I will start summarizing these three cases. One was from the early 1990s from the Philippines. This case is called Oposo versus Factoran. And it was a class action represented by Antonio Oposa, a lawyer and environmental activist, on behalf of 43 child plaintiffs, including his own children, against the environmental minister Factoran. And the case was launched to basically to stop the destruction of the rainforests in the Philippines. Oposa raised the idea of intergenerational equity in this litigation, and the child plaintiffs in court asserted that natural resources belong to people of all ages, including children and all future generations. And surprisingly, the Supreme Court of the Philippines found no difficulty in ruling that children can, for themselves and for others of their generation, and also for the succeeding generations, file a class suit. So consequently, children were given standing as representatives of the future generations in court. While the Oposa case was not expressly a climate change litigation, more generally about environmental degradation, the Juliana versus United States case, which was launched in 2015, was a landmark climate change litigation. And this case was brought as a motion of a nationwide petition series by the NGO called Our Children's Trust in the United States against the federal government for violating the child plaintiffs' constitutional rights to life, liberty, and property, and the right to essential public trust resources on the basis of constitutional rights. And the government is violating these rights by permitting the production of fossil fuels in the country. So like the Oposa case, the Juliana case, and other cases represented by Our Children Trust are typically characterized as lawsuits about intergenerational equity, except that a major legal invention was in Juliana case, that children were not like legally representing the future generations, but there was one adult plaintiff in the case, Professor James Hansen, who is a climate scientist. I'm sorry, I just realized that I'm speaking in past tense about this case, but this case is actually still ongoing, so I should speak in present tense. So he is representing still the future generations as the guardian of the future generations in the case. By contrast, the district court judge in ruling the case found that it was unnecessary to address standing of future generations by this litigation because the youth plaintiffs had adequately alleged current harm that they suffer. So some scholars argue that the ruling implicitly assumed that the interests of future generations and current children are identical. That's a very new approach by the court in climate change litigation. And so the court essentially said that it is sufficient to consider the interests of the living plaintiffs, so the children alone. As a consequence, this decision shifted the focus from the future generations back to the living plaintiffs, and that is children as a generational group. The third case I would like to mention is very new. It was launched in November last year, in 2022, after 2 years of intense legal preparations by the youth organization Aurora in Sweden. So this is a grassroots litigation, not represented by an adult-led organization or a law firm. It is actually represented by young people themselves. And by mentioning that, it has more than 600 plaintiffs in the case. And these plaintiffs also take on the role of representing future generations in the case. So they argue on intergenerational human rights as well in their petition. In short, the young people of this Aurora case argue that the state is not complying with climate mitigation obligations under international and national laws, multilateral agreements, and the European case law. So they also argue on intergenerational grounds, stating that the group members, which is the young people, are expected to be particularly hard hit by the escalating climate crisis because they are expected to be alive when climate change causes serious health consequences for people in Sweden. They also argue that today's children and young people, as well as future generations, risk suffering the most as a result of climate change. So this table that I drew aims to show the common features and the differences between the three cases in terms of representation, legal representation. So the Juliana case is mixed because although it is James Hansen who is the guardian for future generations in the case, but the Juliana case is very famous for public announcements and children's appearances in media coverages, etc. And children take on the social role of representing future generations for this litigation. So they publicly speak about how they see their own responsibility to represent future generations. And then, of course, the Aura case and the grassroots nature of that litigation raises the question whether children do actually feel a genuine responsibility for representation of the future generations. And in comparison to the other two cases, the Oposa and the Juliana, children were not appointed to speak for the future generations. I'm going to use Afi's words in this, so they don't just land their faces to represent future generations, but they actually take actions on it. So, okay. These strategic, I'm sorry, just 1 second, okay. These strategic climate litigations have legal and social and moral implications. They are very new strategies, litigation strategies, in terms of including marginalized and voiceless groups, such as children, who have historically not really had access to justice in environmental or climate change cases, and the voices groups apply to future generations who obviously do not exist and are not present. These cases also very harsh about the time factor of climate change. They use language on climate change is here and now. It will have major impacts in the future. It causes an emergency situation for the world, and children and future generations will experience these impacts throughout all stages or their whole lifetime. And of course, these strategies aim to achieve social change, and that is intergenerational justice. I'm sorry, that is understanding or advancing intergenerational justice as a moral imperative for the living humans. These cases aim to advance intergenerational equity, and as seen, they pursue this goal through children as representatives. Of course, it gives us the question that what if children are not granted standing in court? Who will represent children? Is it another proxy group, a proxy age group to children, or is it going to be random petitioners, a legal guardian or representative, child rights specialists and agents? So it raises a lot of questions about representation and also about consent, especially with regard to the future generations who don't exist. So it is assumed that children's and future generational interests are very similar, if not the same. And so that gives the ground for representation of future generations through children. It is also not clear that of course, that abstract, how would I put it? So that as abstract concepts such as future generations can legally hold rights. And by the time individual rights holders are born, they are not in a position to object to policy decisions that led to their circumstances of conception. And basically, it is up to the courts to decide on how they interpret the rights of future generations. And of course, litigators do have legal arguments, which are human rights-based arguments on the basis of international law and national laws, constitutional rights, etc. Again, they are also implying the obligation of all humans, especially those in power of decisions, for enforcing a climate action as urgently as possible. Okay, and now I would like to look at how children actually perceive their role as representatives for future generations. And I brought this quote, which I don't really see now fully on my screen, so just one moment. Okay. It's hard for legal experts to deny the rights of young people. We are the future. They will be long gone before the long-term effects of climate change ever hit them. It's about my kids. It's about their grandkids. So wow, this is a complicated sentence. It was said by Nick Vanner, one of the child plaintiffs in the Juliana case. And of course, it is very confusing and complex how this whole concept of future generations is mixed with the concept of being children in the present. So is this representation of future generation and intergenerational burden on children? The justice issue and children's, obviously, children have a large sensitivity towards justice issues, and they want to take on the representation. They stand up for the vulnerable, the marginalized, the voiceless groups, and they feel a moral duty to protect and represent them. This is shown, for example, in the Juliana case, where children actually go out and speak about it, and also shown in the Aurora case, as I mentioned, that young people as a group argue for the human rights of future generations in their litigation. Yes, but what makes them think that this is a moral duty for them? It has to do a lot with understanding the common understanding of future generations in the public language, in the political language, in the legal language as well, which is very confusing and complex. So, for instance, it is very typical to hear that it is about children's future, it is about children in the future, or children will be impacted in the future. And then, of course, it gets confused with the future generations concept. And then politicians often address children like, children, you are the future. So it is very interesting how it's being suggested to children all the time that they are absolutely linked. They have a transgenerational obligation to take on and defend the rights of future generations as well. So is this an instrumentalism? Are children being used for advancing the human rights of future generations? And or is it a win-win situation? It's really hard to tell. I think it's up to looking at cases separately, case by case. It depends how children actually experience their role as representatives of future generations. But of course, we can already outline a couple of positive impacts of this whole concept. Intergenerational implications in climate change litigation, where children represent future generations, can help to recognize children's interests in human rights with regard or in relation to climate change law and governance actions. And it may also help to advance human rights of other vulnerable and voiceless groups, such as indigenous groups, girl children, people with disabilities, elderly, etc. These litigations can also help to clarify the terms by the courts, whether children can be identified with future generations, whether they have the same interests, etc., as we saw it, for instance, in the Juliana case. And it can, of course, help to elevate social and political sensitivity towards future generations and our transgenerational link to the people, the people to be born. It can enhance intergenerational justice sustainability, more direct accessibility to participatory forms such as activism, participation in political negotiations, and further participation or further enhancing litigation. It can also empower children and giving them voice and learning experience, the feeling of responsibility and altruism, and also the ability to acquire knowledge on agency and representation, even in legal procedures. But of course, as I said, there are also negative implications or risks and ethics issue that should be discussed in this regard. So at this point, the unclarity is still prevalent about children and future generations and the link between them, even in legal terms. Some litigation petitions actually mix these two concepts. This can also, I mean, representing future generations and children in the same litigation can also create different interest groups in the face of climate change, which can also create a possible tension by allowing the case or the court to lose focus from children in the present to other groups, other interest groups, such as future generations. It can also shift the intergenerational or transgenerational burden onto children, as I already discussed. And it can accelerate further risks such as fatigue if children or the future generations don't receive admissibility or standing in court. They can experience disappointment, anger. They can have mental health issues about feeling overburdened, etc. And then, of course, it raises the question whether children are really representing future generations in court, meaning, do they have a real chance to participate, to stand in front of the court and make their case, assert their arguments about intergenerational equity? It's a question that we can raise. So finally, I brought you some idea about how this representation could be approached in an alternative way. The Urgenda case from the Netherlands is quite unique in terms of approaching the idea of interest groups in the case. So it was found by the first instance court in the Urgenda case that Urgenda itself, Urgenda was is an NGO in the Netherlands who represented this litigation, and there were more than 1,000 plaintiffs in the case, including children, but typically civil participants. So the court decided that Urgenda itself could invoke interests of both people outside the Netherlands and for the future generations, since this organization, Urgenda, had its own bylaws that stipulated that this NGO strives for a sustainable society. And so the court said that this sustainable society actually includes all people in the Netherlands, including children and other interest groups such as elderly, vulnerable groups, and other groups, and including also future generations and people outside the Netherlands. So the court looked at the whole group of people who are gender represented as a collective, and did not, the standing for the civil plaintiffs didn't stand for the appeal court. From the first instance on, Urgenda took over the representation of the entire sustainable society. And that was a very unique approach, in my view, for representing children and the future generations and other interest groups in the society. So that concludes my my presentation. Thank you very much for your attention, and I'm also very eager to hear the questions. Thank you.
Thank you very much, Kata, for your presentation and for raising so many interesting points. I'm aware of the time, so I will keep my questions and the audience question as short as possible. I want to start by asking an issue that featured and permeated all of the presentation, and that is the inadequacy or inefficiency of existing legal norms and doctrines to actually respond to the issues raised by the climate change crisis. So it has become evident that we need a kind of legal innovation in many aspects when it comes to reshaping the role of the courts, when it comes to understanding differently existing rights or interpreting them differently. So I would start with a question to Aoife about the role of the courts, and I find particularly interesting to how courts will reshape their role to close the gap of representation and rights protections that we witness in terms of future generations and children. And what would be the justification? What would be the answer in answering some of the objections? Will it be to look closely the representation of children if it is inadequate? And I was looking forward to your views on this.
Thanks very much, Asteropi. I mean, I think it remains to be seen. I mean, I'm slow, given how context specific the different litigation is and the different judicial engagements are going to be in many ways. I think I certainly, and I know you wouldn't be looking for this, I certainly wouldn't suggest there's going to be a general, one size fits all approach to addressing these issues. And also it will depend on, for instance, the scope of the legal, the constitutional provision that they're dealing with in the cases I'm talking about, which will shape things like judicial willingness to engage with rights in this area. That will be a factor. If you're dealing with express rights, there may be greater judicial willingness to push back against traditional conceptions of the separation of powers that you wouldn't find elsewhere. So rather than trying to suggest that there's one solution, I think what I would point out is that I think what's very important is that we are seeing these cases, and judges are slowly, and not always enthusiastically engaging with the issues. And I think that there is definitely lessons to be drawn in terms of how we will see a cultural shift. And by that, I mean a judicial cultural shift, particularly at the national level in different places. There's lessons to be drawn from the way in which courts, while initially reluctant, have proven much more willing to deal with, for instance, economic and social rights claims and strategic litigation in that area. And I think there's lessons there for us about how arguments have been made successfully to courts and how courts have engaged and where they've pushed back and where they've not. The other area, of course, that I think will provide insights to litigators and to academics working in this area is the way in which children's rights, having gone from being really, say, 20 years ago, very external to decision-making in many national jurisdictions, is now very much part and parcel of that. And there's a much, again, it's not always progressive, it's not always uniform, but there's a much greater sense of the role of courts when it comes to enforcing children's rights and the role that they should play in different ways. So I suppose I'm afraid that doesn't really answer your question in terms of providing you with what do I think the courts will do, but I think it shows where we can look to see how courts might engage with these issues. But I mean, I think key factors will be the extent to which there is meaningful protection at the domestic level in terms of children's rights and future generations' rights, and also the different constitutional frameworks and different constitutional contexts in which we find ourselves. I'm conscious that we're limited for time, so I was also going to ask a question in the Q&A, if that was all right with you, Asteropi, before handing over to Kata, who I'm sure will reply as well. One of the questions is about, do I think it's more effective whether similar claims, in light of the definition and just disabilities issues raised by human rights or constitutional claims brought by large classes of claimants, do you think it is more effective when similar claims are made by a selected group of individuals? And comparing Anjou in Canada and Mathieu in Ontario, I'm not sure if it's about necessarily identifying individual applicants. I'm not sure whether that's important, but I think it's very important to make convincing arguments around the cohort or the class or the group that you're dealing with, whether you're dealing with named applicants or not. And I think ultimately Enjeu fell because the courts were unconvinced by the cohort, this idea that it applied to people under 35 and under. Well, why? The courts say, why is that? What is the arbitrary? And I think one of the things we're doing as part of the CRISL project is trying to provide resources, and these will come up in the next couple of months, trying to provide suggestions to people about how to make those arguments well. And clearly it's important to rely on, you know, legal definitions that will help you, and also to link very tightly when you're arguing for the rights of a particular group in the climate change context, whether existing or future, to tie that very tightly to evidence, and evidence of environmental harm impact. I think that would be, I think the issue was, it wasn't so much whether there were named applicants, it was the fact that the group as defined was arbitrary because it wasn't clear why it was 35 and down. I wanted to also flag that I just respond to something that Kata, I think, brilliantly expressed in her presentation around risks and ethics issues. I think it's a huge issue. I think there are particular challenges when dealing with children in climate justice litigation, because frankly, so much of it is brought by litigants who do not have a background in children's rights, who have not developed. You are seeing many people coming to children's rights issues for the first time as an extension of their climate justice practice. And that means that they don't necessarily have the child-centered or child rights-centered practice you see amongst litigants working in other areas of child rights strategic litigation. And again, and I'm sorry for shamelessly plugging the project, but we're working at the moment on a guide. Something we did as part of the Advancing Child Rights Strategic Litigation project was to develop a guide, key principles around child rights consistent strategic litigation practice. And we're adapting that, myself and a colleague, create a tool for climate justice litigators who are doing their level best and are doing such important work, but need perhaps a little bit of extra help and support when evaluating and also addressing the risks and ethics issues. And I can see, Kata, you're going to have to take a look at that before we finalize it, but I'll leave it there.
Thank you very much, Aoife. Kata, would you like to follow on some of the points when it comes to the risks and the child-centered approach in climate litigation and some of the points that you raised?
No, not particularly, but thank you very much. I will absolutely love to to have a look. I'm very eager to see it, and maybe we can have discussions on it.
I'm aware of the time, but I do have a question that I was thinking during both of your presentations when it comes to representation of future generation. In addition to the definition challenge and what exactly constitutes future generation, if children are future generations, and what is the status of that. When it comes to adult representation of children, even if shared interests were guaranteed, in some magical, non-realistic way, and we could say with absolute certainty that adults would represent children's views. Actually, could we ever be sure that adults could represent children's views in an adequate way, or as adults, they are so far away from their childhood, and we are so far away from what constitutes a children's view that we are ill-equipped to actually understand it and meaningfully convey it to an audience? Could we ever say that adults could represent children, or we should push for more direct participation of children, as we saw in the Sachi case, where children directly participated, and that would potentially bring a new standard for child participation and the understanding of Article 12. I don't know if Aoife or Kata, you would have any insights on adult representation of children.
Let Kata begin, because I've spoken already. So Kata, you take this one, go.
Oh, thanks. So, well, it's a very complicated issue. So it also depends case by case how we approach this representation, or adults being agents, or as I refer to them in many of my research, which is adult acting as bridges between children and decision makers. In principle, children's rights scholars and experts usually argue for direct participation, and that would be very ideal. But we all know that it's it doesn't always align with the reality and the real possibilities in court settings, for instance. Okay, so of course, there are cases where it is essential. For instance, the case in front of the Committee on the Rights of the Child, it was not a question whether children would be heard, because it is a body that actually stands for children's rights, including the right to be heard. So obviously that was a case where children had to be heard in court. And then what could I say? So I don't see much problem with representing children in court by adults or adult lawyers, legal representatives. But of course, it raises the ethics issue and the problems whether children's views can be transmitted the way that they actually want to assert it. So these legal representatives really have a role in engaging in dialogues and participatory processes with children before standing in front of the court and putting forward children's messages.
Thank you very much, Kata. I wish we had another hour or 5 or 6 days more to discuss, but I'm afraid we are short for time and 2 of our panelists had to go already. So at this point, I will wrap up. I would say thank you so much for everyone for your active participation and for your time sharing your insights and knowledge on this topic on a significant issue. Also, many thanks to the audience and panelists on behalf of Alicia and Maria Antonia, who had to go. And I look forward to see all the ongoing developments and how this trend of climate litigation when it comes to children's rights develops in your research. So thank you very much again. And I look forward to continuing the discussion.
Thank you so much. Bye.
Thank you all very much. Have a great day or evening.
You too.